Many clients have approached me over the years with the idea of adding kids to the title to their house, thinking that will really simplify the estate, perhaps avoid probate, and save a lot of money. Before they do that though, I ask them to consider some of the other consequences. It's one of those issues where maybe we've solved one problem and potentially created a lot of other ones in the process. For example, there's the loss of control. I had a client several years ago, elderly lady, wanted to sell her house. She had added her 2 children to title. She wanted to sell the house to a family member who had been there for her for many years and helped her going to the doctor, going to the grocery store. And she thought, what a wonderful gesture to be able to sell this house to this young person at a little bit of a discount from the full market value. Guess what? The kids said no. They refused to sign the transfer and forced mom to list the house with a realtor before she could sell the property. Then there's the tax consequences. Most of us, when we own our own house, don't have to worry about any capital gains tax because it's our principal residence. Under the Income Tax Act, we're only allowed to have 1 principal residence. So what happens when you add your kids to the title and the house goes up in value? If they also own their own house, they're looking at potentially paying income tax on the increased value in the house that they're now on title with. That's your house. And so now we've got some income tax issues to deal with on that property. Then there's also the issue of potential estate claims and complications. I've seen situations where mom or dad adds one of the kids to the title thinking that's okay, that kid will do right by me and distribute it to all the others, and then that child decides, no, I think I'll just keep it for myself. Or the intention was to have the house go to one person, and then the others make a claim saying that that person's not even entitled to it because after all they didn't pay for it, it was just given to them gratuitously. Now they make a claim against the child who's on title, and now we've got a complicated, expensive estate battle to deal with. The Supreme Court of Canada has determined that just because you're on title doesn't necessarily mean you have the right to acquire the property. Where the circumstances warrant that this property really belongs to the estate, then that's where it should go. So these kinds of competing claims against the estate can really complicate things and greatly increase, far more than the cost savings by avoiding probate. And finally, what about the person that you've put on title? What happens if they get divorced and their spouse says, oh, I think I know how to get a little bit more money out of my spouse. I'll just file a claim against their parents' house. After all, they're on title. Or what happens if they get involved in business and they run into some financial difficulty? The creditors decide, oh, I know how I'll get some more money out of this person. I'll file a claim against that house. They're on title with their parents. The end result is the desire to save a few dollars on probate can open an entire can of worms with many issues that can be far more costly than the savings by avoiding probate. Most people don't realize that the cost of probate is, at least in Alberta, really quite modest. The filing fee is a maximum of $400, and even the legal fees are only like 1-2% of the value of the estate. So before you start adding kids to the title of your house or adding them to your bank account, carefully consider what are the real consequences to this, and am I really saving money or just creating some other potential issues to deal with? If you have any questions on this or any other issue, just contact us. We'd love to talk to you and hear from you. Thanks so much.